Next case coming for us is Sharp versus Sharp. The same instructions go for this case as well. We are recording, videotaping I should say, so please keep your voices up and stand behind the podium. And the appellant will have up to 5 minutes for rebuttal, so just let me know.
Good morning. May it please the court, my name is Roseanne Schreiner and I represent the appellant in this matter, who is Ms. Lynne Sharp. I'd like to reserve 5 minutes of my allotted time for my rebuttal argument. The primary issue that lies before the court for decision involves the parties' real estate. This matter is a divorce matter coming out of the Wayne County Court of Common Pleas Domestic Relations Division, and the real property that's at issue is located at 13915 Friendsville Road in Burbank, Ohio. My client, Ms. Sharp, argues that this property is marital property. She doesn't object to Mr. Sharp retaining the property, however she believes that she's entitled to 1/2 of her equitable interest in the residence. Mr. Sharp, on the other hand, completely disagrees with this and believes that this is his separate property. As the court's likely to already be aware of, this real estate was purchased in somewhat unusual circumstances. Glenn Sharp had purchased a race car called the Grumpy Jenkins toy race car, and that was done prior to marriage. That's not disputed. The parties are in dispute as to what happened after the purchase. Ms. Sharp indicates that they restored the vehicle together, while Mr. Sharp indicates that it was only him who restored the property, the vehicle. In any event, after the race car was restored, the parties took that race car on tour. It went to promotional events and it went to shows in order to publicize it to try to sell it. Ultimately, it received interest from Reggie Jackson. Reggie Jackson, through a third party called SoCal Collectibles, reached out and expressed interest in purchasing the vehicle. Rather than doing an outright purchase of the vehicle, the parties had agreed that the Sharps would locate a piece of real property that they wanted to purchase, and that would ultimately be used as a trade with this vehicle. The Sharps went house shopping, figured out what piece of property that they wanted to purchase, and the house on Friendsville Road was purchased.
What formed the basis of that agreement?
What formed the basis?
Of the agreement to use this method to purchase the property? What was behind the agreement?
So my understanding, and based on the testimony and evidence in court, was that Mr. Sharp had asked for this trade to occur. That trade needed to occur for two purposes, according to him. One, he had not paid any taxes. He had not filed any income taxes since the 1980s. So through that entire time period, he had no taxes paid or filed.
Was it established that there would have been some liability had he done that?
We don't know.
Don't know.
And he didn't know either, but he indicated that he didn't want to be responsible for it if there was.
And let me ask you a question. If there was, if he did have liability, would the IRS have been able to attach that property in her name for his debt?
No. Because, and that was the whole premise of how this all worked out ultimately, when the trade occurred, that property was placed in the sole name of Lynne Sharp and not in Glenn Sharp's name whatsoever. So the race car didn't have an actual title to it. The bill of sale that shows the trade shows that the seller of that vehicle was Ms. Lynne Sharp. The purchase, or the quitclaim deed, let me step back. The purchase by SoCal Collectibles of the property on Friendsville Road was in their name, and then they quitclaimed that deed to that property solely to Lynne Sharp. So Glenn Sharp's hands were completely off of the race car as well as the property in the swapping of the race car for the property. Mr. Sharp also testified that not only did he do it because he had unfiled tax returns, but he also did it because he didn't want to pay taxes on the sale of this race car if it sold for the $255 that was associated with the swap and the purchase of the real property. So, fast forward several years, we have a property, a real property, that is in the sole name of Lynne Sharp. We have a race car that's no longer in Ms. Sharp's name and was never in either of their names, but she is on the bill of sale. Mr. Sharp indicates that the reason that he made this agreement for the bill of sale to be in her name and for the quitclaim deed to be solely in her name for the real property was because he hadn't paid taxes for several years, hadn't filed taxes and paid any resulting liability from it, and that he didn't want to pay taxes on the sale of the race car. He also indicated that he did it for estate planning purposes. Ms. Sharps argued, first of all, that the real property is not his separate property, based on the circumstances in which it came into her possession and her name. But if the court believes, as the trial court believed, that it is his separate property, then we would argue that there was an equitable interest gifted to Lynne Sharp by Glenn Sharp as an inter vivos gift. I'm sure the court's aware of the three-pronged test that the court's required to consider when an inter vivos gift is argued.
Counsel, can I ask you a question? So the car, the initial transaction, there was no title to the car.
Correct.
So the initial transaction was in the name of your client as well.
Yes, there is a bill of sale that shows that that transaction is from her, and that is part of the record.
Because there is no title, would taxes have to have been paid on that sale?
I guess we don't know because there wasn't a sale, there was a trade.
And then there was no testimony as to what would typically happen in a sale
Correct.
type environment.
Correct, and we
Without a title.
didn't even get to that because Mr. Sharp was very clear about what his intent was with how these circumstances took place, which is very important to our argument of the inter vivos gift. I think it's uncontroverted that the property was delivered to my client. So if this is a separate property, the real property located on Friendsville Road, that was clearly given to my client or delivered to her when the quitclaim deed was placed in her sole name. She clearly accepted that gift. Now, sometimes people argue that that was done because of coercion or something improper of forcing. Mr. Sharp was very clear that no one ever forced him to do this, that it was his suggestion and his requirement based on those other factors, and that Ms. Sharp never pressured him to do it.
So,
I'm sorry.
no, you go ahead.
My question is, she knew about the tax liability and the fact he had filed his taxes.
She indicated on the record that that was actually not something that she was aware of prior to their marriage. She indicated that when this was done, what Mr. Sharp had indicated to her was that he didn't want to pay taxes on that vehicle, but he also indicated to her that he wanted her to have a nice house. They hadn't had a nice house together. This was a piece of real property in the country. It was something that she had fallen in love with, so he wanted to make sure that he made that purchase happen for her.
So counsel, in follow-up to Judge Theodosia's question, you said she didn't know prior to their marriage about his failing to pay or failing to file tax returns and maybe some taxes. Did she know, though, when he asked her to put her name on the bill of sale?
She indicated that she did not know that.
Why did she think he was putting, I can understand the inter vivos argument, but why would she have to put her name on the bill of sale?
Because that's what he asked her to do. And so she followed what he asked her to do.
So she's claiming she knew nothing about this fraudulent conduct that was going on.
Correct.
Because counsel must understand that the allegations that have been made in these briefs are talking about possibly illegal actions.
Absolutely. Absolutely. And you'll see from the record that my client religiously filed her own tax returns because the parties had agreed that they would always file separate tax returns. And she filed hers every single year and continues to file them every single year.
So she testified to that.
Yes, and it is part of the record to show that she had, I guess aren't tax returns back to the date that they were married, but she testified that she always filed her tax returns, and no one has disputed that through this process. The trial court found that there was no donor intent with regard to the property being placed in Ms. Sharp's sole name. Specifically, the trial court indicated that there was no indication that there was an immediate gift or immediate intent to gift this property to Ms. Sharp. In looking at the case law, we believe that the court has lost its way, the trial court has lost its way with regard to finding donor intent. The trial court said, first of all, there was a letter that was presented to the court as part of the exhibits that indicates that that Mr. Sharp wrote this letter to Ms. Sharp and indicates that he saw this purchase of saw the Friendsville Roadhouse as something we did together, and without you, it would only be a place. During a deposition that was also part of the record, there was questions of Mr. Sharp with regard to that letter and his intent with regard to this property.
Counsel, I'm sorry, I was asking questions and I didn't realize you're actually into your 5 minutes. Do you want to stop now or do you want to continue on?
If I could just continue a
Okay,
little
go
bit.
ahead.
He indicates during that testimony that he always thought it was our home. We were married, we've been married. That indicating that he had made an immediate donor intent, immediate gift of this property to his wife. But in addition to that, if there was no donor intent found with regard to the letter, we also have the issue of what his actual intent was through his own testimony for putting this property solely in Ms. Sharp's name. And he testified on the record that he did it in order to avoid this property being seized or taken because he had these taxes that hadn't been paid. He was basically shielding this property from creditors. There are several cases found throughout the state of Ohio through the courts that have found that that exact reasoning is intent, because the intent is to gift it to somebody to alleviate yourself of responsibility or some fault.
So he's admitting it's a sham transfer is what you're saying?
He admitted that he intended to purposely put it in her name so that no creditors could come back, or specifically the U.S. government, with regard to his failure to file and pay any resulting tax liability from it. If this court allows the trial court's decision to stand, we're basically allowing him to be rewarded for a sham, rewarded for taking something that he truly intended to make a gift of and use it to his benefit. And so by his own words, I think that we have proven that there was donor intent of an immediate gift to his wife. And we would ask the court to find the same and overturn the trial court's decision. Thank you.
Good morning, Counsel, Your Honors. My name is James Richard. I represent the appellee, Lynne Sharp. And with everyone's permission, I will refer to the appellee as Lynne and the appellant as Lynne. And as far as I know, Your Honors, I have not been exposed to the virus. First of all,
Keep it that way.
First of all, as normally or oftentimes happen, there is a dispute of fact, and I have to address initially something that's been said already that I dispute. One, there's extensive deposition testimony and trial testimony on the filing of or not filing of income tax returns. It was a joint decision to file this way, and that's in the record, in both the deposition and the trial testimony.
What do you mean by file this way? You're talking about...
She filed separately. He did not file. The testimony actually indicates he went out and prepared these returns. They were exhibits at trial, these back taxes, and they discussed filing them and paying the interest and penalties and decided not to, and used the money for some, marital money for some other purposes. And consistent with that, jumping ahead a bit if I may, Your Honors, that the trial court also, in its division of property and its decision on the other assignment, attorney fee award, assigned all potential tax liability for this entire transaction to Glenn. Now, what happened here is not tax evasion as alleged in the briefs and the title evidence, Your Honor, and that's in, Your Honors, is in the record. This drag race car was never titled. Most of them are not. I respectfully submit there's no sales tax issue here. And what happened, just like in real estate, Glenn went to a certified public accountant, not just, he got competent accounting and tax planning advice to structure this clearly as a like-kind exchange, and that is what it is, for the purpose of not paying tax on this sale to Reggie Jackson, essentially was who it was. So that is a perfectly legitimate business transaction. I respectfully submit it's not, that there's no sales tax issue for the Department of Taxation here. The question is, arguably, on a subsequent audit by the Internal Revenue Service, did this qualify as a like-kind exchange? But there's no, with all due respect, no, I don't see any possible question of illegality or anything of that nature.
Well, but both briefs have said that the reason why he wanted to do a like-kind exchange was in order not necessarily to avoid sales tax on this, but he was concerned about the IRS coming after the property period because he hadn't filed taxes and so on.
Well, I'm not sure. Your Honor, I will defer to you, Judge Carr, on what my brief may indicate. I don't recall that's being specifically stated. What the trial court found and what the evidence indicates that, is that the purpose of this was to avoid paying any taxes on the sale of the grumpy car. That was the purpose of the like-kind exchange. That was the sole intent of the parties of Glenn at the time of this transaction.
What kind of taxes would
And
those
that's
have been? If it wouldn't have been sales taxes, what kind of taxes would it have been?
The gain on the sale, he paid $11,000.
Capital gains tax.
In 1979, by bill of sale, he paid $11,000, sold for $300,000. Okay, so that was the issue. It's just like selling a commercial property in downtown Worcester, you can defer the gain. And now it's deferred to what is traced to the residence in question here. So that's, we respectfully submit, is, these innuendo of illegal transactions. These are commonplace transactions, I respectfully submit.
Well, I hope it's not commonplace transactions that somebody hasn't paid taxes or filed a federal income tax return in 30 years, 40 years.
No, Your Honor, that was not what I was indicating.
I know, I have to say, just to everyone
Right.
concerned.
But that issue,
Counsel, I'm trying to make one. I have to say to everyone concerned, it was very disconcerting to me reading this brief, these briefs, because it's just common that people do this, and it's like, no, it's not. And maybe that does happen a lot in domestic relations cases, but I have to say, I was a little taken aback by how forthright everybody was in regard to all this.
well,
And it's not that I want you to be forthright, it just seems,
well,
It is domestic relations.
we addressed the facts, Your Honor, and I just understand respect.
I'm sorry, Judge, not laughing at
I'm
you,
sorry.
Judge Schaefer
So
said
it is domestic relations, just saying.
Okay.
she has a background.
Well, I understand. Well, yeah, that's correct, Your Honor, but if there's anything that was undisputed is the taxes or failure to file. We heard a dispute this morning was discussed by the parties at the time of the marriage, and those issues did take place, and we submit there's competent evidence in the record to leave it like that at the wishes of both parties.
So if it turned out that there would have been taxes owed on that property and it wouldn't have qualified for an exchange, then it would have been shielded because he put it in her name, right?
That might be one argument would make in a subsequent audit down the road within the next 5 years or
So he
something.
did get a benefit from it by having it in her name and not in his name.
Well, through the like-kind exchange, yes, and that was the way it was structured, yes. But, you know, another thing, Your Honor, on the separate property status here, we've all seen a lot of these claims. The tracing evidence and the documentary evidence here is quite honestly overwhelming. It's extensive. It goes back to the purchase in 2009. There are numerous trial exhibits of the pictures when Glenn was a young man. And the evidence, as the trial court found, did clearly indicate the common and credible evidence that the Grumpy's toy was fully restored long before the time of the marriage, and there was no increase in value during the marriage. And that is the specific findings, and with references to exhibits of the trial court in its decision. And
Counsel, I think the appellant has argued that they did do some work. I understand she's also arguing they did all the work. But isn't there an agreement that at least a couple things were added to the car during the time of the marriage?
okay. What the record does indicate, and it was actually Glenn's testimony, is that he had taken these steps to restore it as the value was, quote, grumpy in his history in drag racing. He, before the marriage, not only restored, he bought additional parts from Grumpy. And he had those parts in his inventory. And the only evidence of what I call alleged Judge Carr improvement was Glenn put on those parts that were Grumpy's originals going back to the 70s. Some of those during the marriage, but something like a original carburetor or a different carburetor that was Grumpy's or something like that.
External oil pump and a windage tray.
Right, okay.
Same.
So, yes, Judge Carr, there was testimony. It wasn't really, it came from Glenn. He said that this was something I had, this was something that was, I put on it, but the value was the value. And Glenn, in the other documentary evidence, also indicates, Your Honor, that the real value of this car was its age, and the fact that the buyers out there, you know, are mostly dead. It's like so many, and that was the testimony of that's in the exhibits that were stipulated to. That's the exhibits were introduced into evidence of this value, establishing the value. So we submit there was no credible evidence of increase in value to the marriage, and there's a specific finding by the trial court that Grumpy's toy at the time of the marriage was worth at least $300,000.
Mostly because it's tied to the drag racer, or because it's a older vehicle, classic vehicle with original parts. I mean, original parts increases the value of the vehicle substantially.
I respectfully submit, Your Honor, that it's both, and the evidence indicated that the vehicle, because of Grumpy's name in the original parts, had significant value, but this type of chassis, as I understood it from the evidence in this record, the frame, so to speak, was unique, and there just aren't any out there. And there's obviously, don't misconstrue this, there's obviously a reason somebody like Reggie Jackson wanted it. I mean, because...
You know, I'm curious.
Yeah.
Are we referring to the baseball?
Yes, that's what it is.
Okay.
So that's where that is. But we submit, as the trial court found, that there was no evidence of any intentional, voluntary, immediate possessory interest.
How would you respond to the case law that's cited by opposing counsel as to intent? You know, it seems to say when somebody shelters their assets from financial risks, courts have found an intent to create an inter-buyer's gift.
Well, Your Honor, I would say that goes back to what the argument was made earlier, that this was not a transfer into fraud of creditors, but structured as a valid transaction, and was not designed to pass that benefit of shielding it from, if that's what you want to call it, of shielding it from creditors. This
How
was,
does that fit with his statements, though, that he wanted to protect his wife and make sure that the house, if there was tax liability, that she would retain the house free and clear of any claims?
well, the tax liability, when and if taken, it was designed that way if those claims were presented. But as I said, they were not presented at the time of divorce, and they haven't been, as this record indicates, presented since then. And all of the tax liability was assigned to Glenn and a hold harmless and that type of deal. So, and we always, I guess with the risk of stating the obvious, in every separate property claim we all see in a divorce action, there's usually, if not always, an argument of an inter vivos gift. And there's a reason, we all know, for the clear and convincing evidence standard on that, because those arguments are made routinely, and I'm not saying they're inappropriate, but it's something, there's a reason the legislature and the case law has established this, much like they said title to the asset. How it's titled is not determinative. It's all a question of tracing, and the tracing evidence is a controlling factor here, and I submit all of that is borderline overwhelming. I have never seen this much tracing, documentary evidence, I mean, all of this. And the actual agreement does exist, as indicated, with so-called collectibles for the like-kind exchange. So on the face, we're looking at what is in this record, and that was, as the trial court indicated, a legal, valid business purpose destruction of the transaction this way. And
Even
was-
that agreement says it's an agreement between SoCal Collectibles and Glenn and Lynn Sharp. It doesn't say and Glenn Sharp, it says Glenn and Lynn Sharp.
That agreement does say that. I mean, that is.
And it was transferred into her name only, not his. Only.
Well, that was, again, based upon accounting advice of Judge Schaefer from the CPA as the way to structure it. That was the intent of Glenn Sharp about his separate asset. And the money, we don't have it. The money went straight from the escrow to the purchase of this house. We don't have any problem with tracing all that. That documentary evidence is there. That's not even argued as an issue on appeal. There's insufficient tracing or documentary evidence. The money went directly there. And we even traced all of the stages of the improvements when they were done, and restoration going back to 1979. And I think in a lot of times, this goes into the timing of the transaction and the intent of the parties at the time. But these parties were not married until May of 2003. And the action for divorce was commenced in October of 2017. And the evidence, it's on the attorney fee issue as well, indicates that there was marital I mean, we really essentially had a 4-year marriage when they were living together, because there was a concealment of the payment of attorney fees from marital funds for 15 and a half months prior to filing.
You only have 20 seconds for me.
So I submit, looking at all of the assignments of error, Your Honors 1 and 2 are essentially the same argument. There is competent, credible evidence of the separate property status of this decision, as cited by the trial court and in the case law. And there's competent, credible evidence, as found by the trial court, that there wasn't an intent to make it immediate inter vivos gift at the time of this transaction, which resulted in the purchase of the residence. And the attorney fee issue was addressed at length in the briefs. The court took into consideration the concealment of the attorney fees and the allocation of debt as it required to do. Thank you.
Thank you. You have 2 minutes and 21 seconds left.
There is a dispute of fact. Attorney Richard is correct. There's an argument that this was a joint decision to not file the taxes, and that they had been prepared and there was tax liability, and that the parties had jointly agreed not to file them. That is absolutely not what Lynne testified to at trial or at a deposition that was held prior to trial and is part of the record. Moreover, what's more telling is this tax preparer who has allegedly prepared these tax returns and had this conversation about the tax liability wasn't even brought in to testify at this final hearing. So if Mr. Sharp truly wanted to make an argument that my client had knowledge and that these joint returns were not, and that these returns were not filed because of tax liability, then surely that tax preparer would have come in and testified about my client's knowledge. That never happened. The person was never presented. That's not the only thing that Mr. Sharp made an argument about that the court found not credible. The other issue was he argued that there was a home equity line of credit that was placed on this property in Lynne's sole name that he didn't have any knowledge of, and that there had been, his signature had been fraudulently signed to those documents in the presence of a notary. That notary was deposed, and that notary said on the record that that absolutely was not true, and that notary was also not brought into the court for the trial portion, the trial for the hearing. So again, he can say and he can argue, but he hasn't proven those things. And I just want to leave with this thought. Yes, clear and convincing evidence is the requirement for an intro vivos gift. We understand that. We also understand that that argument is made in a lot of cases. However, in this case, you have somebody, even if we believe that it was only to avoid sales tax, it was still an intent to give Lynne a present possessory interest in this property to avoid that sales tax. That shows what his intent was, and that is what qualifies as a donor intent to qualify and to meet that standard of clear and convincing evidence, and to find this property as a marital asset.
Thank you.
Thank you.
The court will take the matter under advisement and issue a written opinion, and that will be sent to both sides.